Hi, contract students. Professor Ortenberg here, and today I'm going to talk to you about conditions, contractual conditions. And I want to begin by simply explaining what conditions are. And I'm going to use an analogy here to a simple household object that you're familiar with, a light switch, because conditions are effectively switches. Conditions are events not certain to occur, that until they occur, some other contractual obligation is not due. That's a mouthful, so let's try to break down what that means. First and foremost, before learning this lesson, you'll need to know a few things about contract interpretation, because one of the first questions that we have is, what is the meaning of terms in a contract? And one of those meanings is to determine if something is a condition or a promise. So if you haven't yet, check on that lesson regarding canons of construction and the application of extrinsic evidence to understand the meaning of contractual terms, because you'll need that here to determine whether a term in a contract is a promise, a condition, or both. This light switch is now going to stand in for a promise. And a promise is a contractual obligation, something that has to be performed, right? Contracts are made of promises, usually two or more promises. The parties promise mutually to do something for each other. And we might think that a contract creates an obligation, but often that obligation is conditional. And that's where the switch comes in. This contractual obligation may be conditional on some condition occurring or not occurring. So let's now talk about what is a condition in the terms of a switch. Well, let's look at a simple light switch. Here is a simple light switch. You're probably familiar with these from your own home, and it has two positions, off and on. It functions in a very simple way. If the switch is in the on position, current will flow between these poles, and if it's in the off position, they won't. And so we can talk about a condition as being a condition precedent, which means it begins in the off position, and unless and until it is flipped on, some resulting promise is not due. We can also talk about things being conditions subsequent, which means that they begin in the on condition, the on position rather. Conditions subsequent begin in the on position, and then something may occur to turn them off, extinguishing the duty. As I was doing some electrical wiring around my own home, I realized that this may not be the best analogy for conditions, because some switches don't have on and off written on them, and in fact could function differently depending on how they're wired. This is what's called a three-way switch, but the key idea is that, and again you may have some of these at home, it doesn't have on or off written on the plate here. It depends which way is on or off on how it is wired. It actually doesn't have just two, but rather three prongs, and without getting into the details of wiring, depending on how the switch is set up, it could function either to turn a light off in this position or to turn a light on in this position. It is simply a condition, simply a switch, but whether it is a condition precedent or a condition subsequent depends on how it is wired or how it is structured. And this turns out to be a better analogy for how conditions work in modern contract law. It turns out that in modern contract law, most conditions could be framed or wired as either conditions precedent or conditions subsequent based on sort of games of semantics. And whether they turn something on or turn something off is really just a matter of, well, perspective or wiring, or again, our artful semantic usage. I might say, I promise to buy your car if inflation exceeds 5%. And that makes it sound like we have a condition precedent. Unless and until inflation exceeds 5%, my obligation to buy that car is not on. I could also say, I will buy your car unless by November 5th, inflation dips below 5%. Well, now I have an obligation that's on, and the effect of inflation is to turn that obligation off. But really, this is a distinction without much of a difference. It's also a little bit more obtruse to think of things as conditions subsequent. So we generally construe conditions generally to mean what used to be called conditions precedent. In other words, the condition has to occur in order for the duty to come on. There are some exceptions to this, of course, as there always are in contract law, particularly in the examples of insurance contracts which do have conditions subsequent. But as a general rule, we're just going to use the term condition to refer to this switch which has the function of turning on or off some promise. Now, when we have a condition attached to a promise, we say that the promise is conditional. This is the condition, and this is the conditional promise, meaning the promise does not have to be performed unless the condition operates. Again, it's like a light bulb with a switch in the circuit. Instead of being on all the time and due regardless of anything, some event not certain to occur must occur in order for that obligation to be turned on. These are also known as express conditions, and they're usually easy to find because they will be written in the contract itself. That's why I started this lesson saying you'll need to understand contract interpretation and apply those tools to determine whether something is in fact a condition, whether it's a promise, whether it's both, something known as a promissory condition, or perhaps whether it's something else or neither, like recitals. It requires the skill of interpretation to answer the question, why is something a condition? The answer may be found in the express language. For example, I will pay you for the car if and only if inflation exceeds 5%. That's pretty clear express language. But we might also look at facts and circumstances, trade usage, all the aspects that pertain to contract interpretation also pertain to determining whether something is a condition, a promise, both, or something else. That's express conditions, and again, they're quite simple because they only have two positions, on or off, occurred or didn't occur, complete, incomplete, circuit on, circuit off. The effect of them is rather simple, so the art and the skill in understanding express conditions, again, is a contract interpretation skill, where we have to understand what parties meant when they said a certain thing. Did they intend for this to operate in that way or not? There is, however, a concept that goes beyond the language of the contract. We have implied terms in a contract. We also have implied conditions. Let me give you an example to think about, and then I'll explain why implied conditions are necessary. If I promise to sell you my car for $20,000, and I show up at the appointed time and you don't have the money, do I have to deliver the car to you? The answer is surely no. Of course I don't have to give you the car. But why? I promised to sell you the car. Promises must be kept. What is operating here that allows me not to deliver the car on that given day, even though I promised to? The answer is the existence of implied conditions. Parties don't always say everything they mean. In fact, no contract is totally complete. And there is an assumption of mutuality in contracts, that my promise to you is based on my receipt of your return promise to me, and vice versa, making these implied conditions concurrent to one another, or let's just call them implied conditions. But it turns out implied conditions look and function a little different than express conditions do. As a reminder, here's our illustration of an express condition. It's in the form of a switch, which has two different statuses, either on or off. We discussed how perhaps on or off could be switched with one another, and that is represented by being blank and not on-off written on it, because whether this is on or this position is on, whether up is on or whether down is on, depends on other features that are not really important to understanding the function of conditions. The key thing to understand is that this condition has only two positions, on or off, and that makes it an express condition. This dimmer switch, however, represents an implied condition, because implied conditions regard a different doctrine that we understand as having degrees of performance. And that's illustrated here by these levels of contractual performance shown by this switch. It can be either off, partially performed, all the way to fully performed as the switch dims up or down the lights. And we treat implied conditions in this way for reasons that are better explained in a future lesson on substantial performance and material breach. The case, by the way, that relates to this issue is Jacob and Young v. Kent, where Judge Cardozo explained the importance of having the doctrine of substantial performance for these implied conditions. But effectively, the way that it works is that even though we have implied conditions to each other to perform our mutual obligations, I don't necessarily have to fully perform in order to receive the benefits of the contract at law. As you can see on the switch, there are different levels that it can illuminate a light, which reflect the idea that performance could be partially performed, completely performed, and there are gradations or distinctions that have an effect on the other party's mutual obligation. So if we have an implied condition, that implied condition functions like a light switch, and it doesn't just have one position, on or off. Rather, it could be slightly on, all the way to fully on. And the difference is that a contract will almost always have some implied conditions in it. The parties have mutual obligations to one another. If one party's conditions are completely performed, the other party has illuminated or caused their duty to become due. If the performance is not completely performed, we have to do a separate analysis of whether or not performance is substantial enough to trigger mutual obligations. And the answer to that question will depend on an analysis found in Restatement Section 242. At some point, the contract has been unperformed for so long and to such an extent that the obligation is forever extinguished and that light switch is in the off position. But again, with implied conditions, as distinguished from express conditions, there are levels or gradations of performance known as, well, starting with nothing or total breach, to material breach, to substantial performance, all the way to complete performance. And each of them have a different effect on the other party's obligations to perform and the liabilities from the party who failed to perform. Using our dimmer switch example, we have a variety of performances going from very dim to all the way illuminated. And so it's the same in the case of performance. Let's say I promise to sell you my car and you promise to pay $20,000. And you show up with $19,999. I think it's fair to say that your performance is almost complete. You are 1/20,000th short of full performance. Maybe that's even indistinguishable from full performance or full illumination of this light bulb. If we were looking at it as a dimmer switch, we'd be well past 99% illuminated. Now, if we were looking at it from the perspective of a standard switch, that switch is not thrown until the threshold is totally met. 19,999 is not 20,000. But that's a harsh result. And so we have a doctrine of substantial performance. In the case where you have 19,999 out of $20,000 ready and waiting for me, I most likely have to perform my implied conditional promise to deliver the car to you. But how much is enough? Well, that's where the doctrine of substantial performance comes in. How much performance on your end is required to trigger my obligation on my end? And we'll have to do a 5-factor balancing test to determine whether or not the performance is substantial or whether there's been a material breach. By the way, if the performance is complete, the solution is easy. In the case of complete performance, the other party has to perform and there's no liability for breach. In the case of a substantial but incomplete performance, the other party has to perform, but there is some liability for whatever the difference is between full performance and the performance that was rendered. If the performance is insubstantial, if there has been a material breach, the other party has the right to withhold his, her, or their mutual obligations in a way of basically getting self-help by saying, I'm not going to pay you until you render performance onto me, and that might incentivize you to complete your performance or at least substantially perform. At some point, however, I've done enough waiting for you to perform your obligation, and I can declare that you have totally breached the agreement. The light has gone out, and now I have the right to cancel the contract and seek performance from someone else. So let's recap what we learned about conditions today. Understanding whether a term in a contract is a condition, a promise, or both, a promissory condition, is a question of contract interpretation. So if I were to ask you, is this term a condition? The answer would have to rely on, for example, using the canons of construction to determine the meaning of intrinsic evidence, or determining whether there is a latent ambiguity in that evidence, making it susceptible to extrinsic evidence, or applying the parole evidence rule to see if preliminary negotiations can add or change a term in the purported agreement. Those are all skills previously learned in the lesson on contract interpretation. And basically we use those skills to determine whether a term is in fact a condition, a promise, or both. Now that relates to express terms and express conditions, which are either fully performed or not performed. There is also a concept called an implied condition. Just like there are implied terms. Terms can be implied in law, in fact, under the duty of good faith and fair dealing. Likewise, there is a concept of mutuality that implies conditions concurrent or conditions generally, where one party's substantial performance triggers the other party's mutual obligation. I hope this lesson helped you understand what are conditions and how to find them. I'll see you in the next video.